Good evening and welcome to Slam the Gavel, the show that tells it all regarding family court, other court issues, as well as CPS. I am your host, Marianne Petrie. This episode of Slam the Gavel is sponsored by CPS Protect Consulting Services. A child protective services case is one of the most frightening experiences for any parent. Don't face it alone. Face it with confidence with Urgent Assist by CPS Protect. You can have access to former CPS investigators to make sure you preserve your rights and protect your family. If you're facing CPS involvement and aren't sure where to turn, their child welfare consultants can help you. Visit cpsprotect.com/subscribe and enter the coupon code SLAMTHEGAVEL for 60% off your first year of Urgent Assist. And this is available in all 50 states. I have another announcement. Bradley's mother, Narcus Golan, passed away in the fall of 2022. Bradley is autistic and needs structured routine and therapies he receives for his autism 6 days a week. However, Italy just entrusted Bradley to Italian social services. If he is ruled to go back, he will face the next 3 to 4 years in the Italian foster care system, where he can't speak or understand the language. He will then be taken away from the only family he has ever known, and we have Judge Ann Donnelly to thank for this. Please call Governor Hochul at 518-474-8390. That's Governor Hochul at 518-474-8390 to please keep Bradley here safe in these United States. Hashtag keep Bradley safe. One more announcement. Go to the site, pleasedoyourjob.com. We need 2,500 more signatures. That's pleasedoyourjob.com. Okay, I'm bringing back on my podcast Elaine Mickman. She's an author. The last time she was on my podcast was season 3, episode 20, and season 3, episode 30. And that's where we talked about how the judiciary is at war with the Constitution and what are we going to do about it. But Elaine's here today. We're going to talk about updates to her case. And she's going to do a book promotion on October 12th. So I welcome you, Elaine. How are you doing?
Hi, Marianne. Thanks for having me. And by the way, thank you for inviting me to contribute to your new book, Raised by These Wolves.
Okay.
And I'd like to say to the audience and listeners, it's a must-read book. It's composed of a collection of true stories from ordinary folks whose lives were turned upside down while fighting for justice for their children and theirself in various legal matters, mostly surrounding, anything with your family. And the book really gives invaluable insight by victims and professionals into the corrupted and dysfunctional, unjust court system. So it's not just one person's story, it's different people from all walks of life. And it really can assist people. It could also be, I hate to say it, but in a sense, comforting, knowing that you're not the only one who may be going through this. I'm not saying it's a good thing. I'm just saying at least you know that you're not an isolated case. So as far as my case is concerned, well, I don't feel like I've had too much advanced movement, but just for the audience's background, after the family court basically invited my ex-husband and his team of attorneys to vexatiously litigate the case to churn up excessive legal fees and torment me and the children through child custody, when ex-husband did not even want to have any visitation, the court then asset stripped me, left me destitute with my minor children. And then they ensured that I would be denied child support until my children were both emancipated. And then I appealed the orders, basically rubber stamps for everything. But when I appealed the very last order, which I was even denied a child support hearing, the state appeals court quashed the appeal without reviewing it, but they entered a 2-page order ordering away my constitutional right to due process and court access to even file for child support. Regardless, the court did not even really have the authority to do so. But one of the things is I also want to remind anyone who hadn't heard my previous podcast. The court had been maintaining two different sets of income records for my ex-husband, his actual income records, where there was a filing by the IRS, something with the IRS, and then the hearsay income, which the court used to use for denying me support, child support, enforcement of any financial orders. And I remind the listeners also that the domestic relations director, the previous director at the courthouse where I go, they tampered the computer system with false and phony entries in violation of state and federal laws. So this is the type of thing that, I've had to endure. So you're not fighting a fair fight or dealing with a real just system when they're playing with different, they're not even using the law or the rules, which is why I came up with the title of my book, Courtgate, The Court's Divorce from the Law, because they're not going by the law. They're just doing anything arbitrarily, whatever suits them for whatever case at the time. It's not men, it's not women, it's not your status really. Wherever the court sees a financial profit or, whoever they're receiving some quid pro quo from, that's the way they decide. They make a decision up front, and then what they do is have to write up an opinion to fit their decision.
So what you're saying is, okay, whichever party has the money, the judge is going to rule in their favor.
Or it could be a connection, not necessarily, not everybody's wealthy, but if somebody has a connection to the court, someone, just like in your case where there was a connection that interfered in your case, so that can occur also. So when I filed that last appeal at the state appeals court, they were actually absent jurisdiction to order away my rights because they quashed the appeal before reviewing it. So they did not review where you submit briefs and they review your case. That never happened. They just quashed it, which means they just dismissed it and threw out the appeal without reviewing it, yet they entered an order. Now, how can you enter an order without even reviewing a case? So they usurped or ordered away, as I call it, my 14th Amendment constitutional right. And that happens to be what they call a non-judicial act. So when a judge enters a non-judicial act, in other words, an order for something they don't normally do, they're not really protected under the 11th Amendment, which is the immunity when they say you can't sue a judge. That's not true. If a judge does not have jurisdiction, they're not the assigned judge, they work in another courthouse or in another division, they're not free to just enter any order. But they do it often, especially at the courthouse, especially at Montgomery County in Pennsylvania. This is a very common practice. Judges will just hijack cases, take over a case. If somebody has a connection to another judge and they're not the assigned judge, they just come in, enter these orders, and you're subjected to it. And your only recourse is to file an appeal. And then the appeals court, you're dealing with this similar type of stuff where they're free to just quash you without any legitimate reason. So in any event, after they entered that order and they quashed me, they wouldn't let me move forward. That actually gave me an independent cause of action for civil rights in federal court. So therefore, I filed what they call a Section 1983 civil rights suit in federal court, but I was not suing judges in Pennsylvania for money. I was seeking injunctive or declaratory relief. This happens to be permissible. The judges are not immune under the 11th Amendment from somebody filing an injunctive or declaratory relief suit. You're asking the courts to take action and do something, not seeking money. So the judiciary, they're not immune from this 11th Amendment.
Mhm.
from injunctive relief, or when they're absent jurisdiction, or when they enter a non-judicial act. However, the U.S. District Court, which is federal court, it's actually U.S. District Court, they dismissed the suit with a memorandum reciting the 11th Amendment, which is not even applicable, and they know it. So that's where I have been left now. Interesting also is that when I filed this suit for injunctive relief against the state appeals court, it was never even served. Those suits have to be served by like marshals. The
Right.
federal court will serve it for you. They never served it, and they dismissed it without service. So now I'm faced with a predicament of appealing that order. However, the appeals court is basically not even involved at this point because they were never served. Imagine trying to appeal an order against the other party when the other party was never even served the suit and never had opportunity. So they have really created a conundrum here, I guess. So as far as ordering away someone's rights, you're protected under the First, the Fifth, and the 14th Amendments of the U.S. Constitution. The Pennsylvania, where you and I live, Miriam, the Pennsylvania Constitution, Article 510C, prohibits the judiciary from abridging a litigant's rights, from cutting off their rights. You're not allowed to. In addition to legislative law, there's 42 Pennsylvania 4902 that provides that the courts, everyone has access to the courts for legal redress, and also the court has their own rule. It's 210 Pennsylvania 63.1, and that states the judiciary cannot create or diminish rights, yet they're doing it. So you can imagine the frustration here when they're just stamping no. And so the other thing I want to bring up is when you try to appeal at the federal court, they also have their little tactics as well. They can stop you from appealing by ordering you to respond to what they call a summary action. Similar to like when someone files summary judgment, when a summary judgment is when a party is asking the court to enter an order without you getting a hearing. They're saying, here's enough facts here that you don't even have to have a hearing or a trial or testimony and evidence. Well, a summary action is the court can say, what you're appealing is worthless, frivolous, meaningless. So we're just going to stop you. So, I'm just saying now here you are at the federal courts, and they have the appearance right now to me as failing as well. So we'll see how that goes when I get a decision, if I can even proceed with the appeal. And an appeal, a first level appeal, is a right. It's a guaranteed and promised right. When you go to higher courts, like let's say you go to your Supreme Court in your state, like in Pennsylvania, that's what they call discretionary. And if to go to the U.S. Supreme Court, another one, discretionary. But when you have a first level appeal, that's a guaranteed promise right in the Constitution. And there's rules that promise as well for final orders. That is, they don't guarantee it for what they call an interlocutory order, but a final order. But they're blocking people as well. So in any event, the crux of our corrupt judicial system is that they do not rule by law.
No.
In this unjust system. It's mostly quid pro quo. And as I said, that's why I named my book Courtgate, the Courts Divorced from the Law. And I plan on putting that on a free ebook promotion October 12th, probably for a few days. And, I also want to say, with my experience, we go to these buildings that they call them courts, but they're not courts of law.
No.
It's like they're calling themselves a court, but they're not courts of law.
It's a kangaroo court.
Yeah, it's nothing more than a business. They are businesses to generate revenue. That's all they are. My experience is that they're robber barons. They're robber baron kleptocracies, and all they're about is generating revenue. They're exploiting vulnerable parties.
Mhm.
They use unethical, questionable, corrupt tactics to asset strip and sanction people. I wanted to bring to your attention also that there's an investigative journalist, Diane Diamond. I
Mhm.
don't know if you're familiar with her, but she just also published a book about a week ago. It's called We're Here to Help When Guardianship Goes Wrong. Now,
Yeah.
you're aware that guardianship is another element in, it's not divorce court, family court, but it's with our families. She included a certain chapter. She wrote chapter that included me and from different records, where the courts, the family courts, are actually, they've been putting guardians on dependent, everyone I know is a dependent homemaker. They could be a mom. In other words, somebody whose spouse works and they're getting, let's say you're getting divorced and you're supposed to be getting either support money, alimony, or a divorce settlement. And they will put these guardians on you without no reason. Most of the time, it's all ex parte behind closed doors. And they will sign away your assets. You have no rights. And then when they strip you of all your assets, they take the guardian off and you are left destitute, homeless, and broke. And this has been going on at least 20 years that I know of. I know of people in Pennsylvania going back 20 years ago that they were doing this, and you can't get anywhere. There's no one to go to. Then now in her book, she also wrote about how they're expanding people who have workman's comp suits where they're getting a settlement. They're putting guardians on them as well, and who knows who else. So anytime you have some money that you're supposed to be coming into, there's predators out there who want to put a guardian on you. So if they can't get you one way, they're going to get you another way, and it's really horrible. So in Diane's book, she has a chapter called like weaponization and divorce. I guess that's the chapter that is focusing on the guardianship in divorce. So this is another just another element of the courts being weaponized against us. I believe Diane spent 9 years researching, getting facts, and all sorts of cases. So typically that was for seniors where they would try to put guardians, but they expanded to, other areas, other groups of people. So it's quite an education. It's constantly looking over your back. We really need privacy laws. Once somebody knows about your assets, they're looking for one way or another to grab your assets. What other issues? I did want to also bring up that there is federal proposed legislation for oversight of the U.S. Supreme Court. Currently, there's no oversight for the United States Supreme Court. So like your state court judges, even federal court, they have judicial conduct boards. There's absolutely no oversight. They're free to do anything they want. So HR 288 had been introduced. I didn't check the most recent status of it. I thought I had read that Congress passed it, but it was at the Senate level. So I don't know the absolute status. And what they were seeking in that bill, they were looking for oversight and accountability of the U.S. Supreme Court. And all summer long, they had talked about perks and gifts that had one of the justices received. And of course, you and I both know it's not one justice. All of them were receiving, they're just focusing on one particular justice, but it's all the same for all of them. It's just a matter of whose is exposed, and believe me, they're not taking these gifts for nothing. It is when they're exposing that the gifts that they're getting are connected or have to do with business before the court. So even if a person has a case before the court and they don't directly hand over a gift, through some web, some connection, some, organization or group, some way, they're getting gifts and perks. And they also have been known to only take cases connected with this historical society, which is another place that people donate money to. So if you're not a donor to that particular organization, you can be sure your case is very, very unlikely to be looked at. They only take like a very small percent anyway of the cases. If you're pro se, what's your chances? Practically zero. If you're not in that historical society, zero. So, these are really important. There's a whole host of elements. The way the court acts, where people are getting rubber stamp denied. It's not one judge. It's not one courthouse. It's not one wrongdoing. It's a whole host of matters that create the problem that we're dealing with. In Pennsylvania, our Judicial Conduct Board, I don't remember if I brought this up. Our conduct board, it's ineffective and dysfunctional. It's all about conflict of interest. I had filed judicial conduct complaint years ago, and my ex-husband's attorney was the chair. So when the judge in the case entered some order that was unlawful, outrageous, no hearing, no due process, and I filed a complaint because of his misconduct, my ex-husband's attorney was the chair of the Judicial Conduct Board. How is that? They're allowing attorneys who are privately practicing to be the head and chair of the conduct board. Then a number of years later, I had to file another conduct board complaint, and it was against a different judge who was presiding in the case at that time. And it had to do with fraud and so forth, where I was defrauded from companies that I was half owner to. I raised fraud, and the judge was, there was a lot of misconduct by the judge. I filed my complaint, and, the complaint was lingering, hanging out there for, my gosh, over 4 years. And finally it was dismissed. But as I found out afterwards, the judge came from the law firm just before the judge became, just before the chief of the Judicial Conduct Board at that time, just before he became the chief, he was a law partner at the law firm my ex-husband worked at, where they were not only representing him, they were involved with embezzling my companies. They were getting directly paid from companies that I was half owner to. They were up to their eyeballs. They ran into 3 different courts. They ran into my family court. They ran into federal court. They ran into Delaware Chancery Court. And it was a conflict of interest because they previously had represented me, my ex-husband, and our companies. And then when a divorce occurred, they were representing him against me. And as it turns out, also, only recently I learned that same law firm has been sued multiple times. They were even sanctioned by the SEC. So they're up to their eyeballs in fraud. But this is what we're dealing with the conduct board as well. It's always a conflict of interest. And the same goes for the disciplinary board with the attorneys as well. If someone has a connection, and you can look on their site and they'll have lots and lots of attorneys who've been disciplined. Well, I don't know those attorneys. I don't know what really went on. And, you read an opinion and we just assume these opinions are accurate. If you read the opinion in my divorce case, the only thing that would be accurate was my name, my name and my address, because everything in there is all fabrications. Oh. So all the case law that you read, when you have to have a case and file appeals and rely on this stuff, and you say, oh, here's all this, you don't know that they're really the facts. You're basing everything and relying on cases, when I bet you most of the people that, if you contacted the parties from a lot of these cases, they would say, that's not what happened. That's not the facts. Here's my actual records. The same as me. They misreport all the facts. Oh, and one other thing, I think I mentioned it before, but many years ago when I first filed that first complaint, there was actually a newspaper in Pennsylvania, a small paper called the Independent Gazette. They actually wrote an article called Millionaire to Welfare based on my case, and it brought up it illustrated how there was no effective disciplinary board for the judges because of the conflict of interest. The newspaper did their own legwork, contacted everyone, and they wrote about what they discovered that corroborated what I had written in my complaint and so forth, and told them. So, so again, back to HR 288 for the U.S. Supreme Court, there's absolute need. The one thing I will say is that there needs to be an independent agency. You can't have a judge overseeing another judge. It's not going to be effective. There's too many conflicts. It needs to be an outside source. And they want to complain that the branches of government, well, you know what? Who doesn't have oversight? What job in this country doesn't have any kind of oversight? And they can't do it themselves. They've proven by dismissing 99% of judicial conduct board complaints that they can't do, that they're not reliable.
Well, yeah, because they're not looking at evidence either.
Correct. That's right. They're not. They are just, it's another thing. It's just another piece of where it's all connections. And so I would like to go back, pedal back to with when you're filing appeals. When my experience, I was at the Pennsylvania Supreme Court trying to file an appeal. This is prior to me filing any kind of federal action. I had gone to the Pennsylvania Supreme Court, but the prothonotary, I should say the deputy prothonotary, which is the office where when you file, they docket it, they stamp it that it's received. Well, the deputy prothonotary, she tampered the docket. She falsely stamped my filing late when all their proof that they have in their records, because they sent me a copy, shows it was filed timely. So all they have to do is stamp it late. And now you can't even get your stuff before the court. So this is another tactic. It's not an accident, because I filed a disciplinary complaint against the prothonotary, the deputy prothonotary, and their excuse was, well, she's a government employee, she has immunity. I said, oh, really? Well, if that's the case, then why did they disbar our former state attorney general, Kathleen Kane? They claimed that she did something that was wrong, and she didn't have protection with immunity. They disbarred her. They put her in jail right here where she doesn't, in Montgomery County, where she doesn't even live and she didn't even work. So they have a different set of, they make up their own rules as they go. So I would like to just read off a few different ways that they rig, common tactics they use, because I'm also familiar with the e-filing stuff as well, even though I'm not an e-filer, but most people I know are. And I'll tell you what they do there. They can block you. So, nobody, it sounds like, what are you, it's so cynical, and, nobody stops to think about, well, if somebody calls your telephone, you can block them today. If you have any kind of smartphone, what do you think all your phone is a mini computer? They can rig those computers to block you. I had tried to file years ago physically in person, and they'd block some of my case because when I tried to file for a fee waiver and I was denied, they have an automatic block on there. The only way you can file when there's a block is the manager in that office has to come out and override it. But I know a woman out near you, Marianne, she filed something about the same time I did at the Pennsylvania Supreme Court. She e-filed it. They blocked her. They wouldn't let her file it. And then she mailed it into them, and they said, well, it's late. She goes, but I have proof on my computer. I e-filed it. They don't care. So these are some common tactics they use in the courts to obstruct a party from any kind of due process. They'll deny and dismiss your case without a hearing. They conduct hearings ex parte without you knowing about it. They'll, when they do give you a hearing, they'll exclude your evidence or witness testimony. They'll allow the other side hearsay without any kind of, they're supposed to have the best evidence rule, where if somebody, you can't just bring a book in and say, here, it says in this book something. You have to have the actual author, and if you need to bring actual witnesses in to testify, and they will overlook that for the side that they're given favors to, but they will have a different standard for you. And then when you have to file an appeal with an order that you are sure it's wrong on the law or an abuse of discretion, they'll often deprive you your guaranteed right to a first level appeal for a final order. And they will quash you. They can quash you for your inability to even pay the filing fees if you qualify financially for a fee waiver, which they call IFP, informa pauperis. That's a tactic they can use. They can deny a person. It could be a poor person who has no ability to pay the filing fees. They'll deny you the IFP, then you can't file. Then they can stamp you late, as I told you, even if you file it timely. All they do is put a stamp on there. You can say, well, they got a machine in there. It's set for that date. Nah, they can do whatever they want. I've seen it happen. And sometimes the court, they will falsify and fabricate facts, and they also alter and edit transcripts. One of the things I noticed was when it took a long time for me to get a transcript, like a month or more, it was always altered or edited. They can't wait to sell those transcripts. It's a moneymaker. But when they make a lot of money from those. But when it takes a very long time, you can be sure that they're altering and edited. If it's a really long transcript, like maybe 1,000 pages, it could take longer than normal. But when you're ordering a transcript that's 20, 30, 50, 100 pages, if it's taking a month or longer, they're altering and editing. I guess that's kind of.
Well, you know what happened to me in my federal thing? There was a telephonic phone conference. So we all get on the phone with all these attorneys. I don't think I ever told you this. But I said to them, I really wish this was on Zoom so I could see everybody, right? And it's like, no, we're going to just do this on the phone. And all the lawyers announced who they were. And of course, I chided one of them saying, yes, it's you. You always get what you want. That's what you do. And so then the judge said, you can e-file. You need to be e-filing everything. And I said, well, no, because your clerk said I can send in my hard copy of everything. And the opposing attorneys are sending me their hard copy. And then he said, my clerk would never say that. I said, well, she did. She said, I can send in my hard copy. And I don't know how to work this e-file system, to be honest. And then we kind of ended the conversation.
Yeah, they just assume that everybody's technical. I'll tell you an interesting thing that happened to me only in the last year. When I had to file an appeal at the federal court for something, it was not family court. It was a collateral matter, something that happened as a result of family court. They had an email right to the U.S. District Court that they gave to me. So it's not e-filing, but an email. It was the courts to their persona, they have a clerk. They call it a clerk there. I sent my, and what happened was because of COVID, the courthouses, many of them were closed down for a long period. So they had this email. Well, as it turned out, I emailed them in my notice of appeal, and I hadn't heard anything back in about 2 weeks, maybe a little bit longer. I decided to give them a call to find out what's going on, because usually, in a couple of weeks, they'll start sending you out some different information about moving forward. And they said, well, we don't have anything. We didn't get anything. I said, what are you talking about? I have it right here. I sent it to you. She goes, oh, we discontinued that email. Oh, well, that email was primarily used by pro se people, because the attorneys were e-filing. They were on that system that e-filed, but for pro se people who weren't familiar with the e-filing, they just gave you an email and it went right to the clerk's office and they filed stuff. And then I had to go through an entire process in order to try and get reinstated, write brief memorandum, backing up why they need to reinstate this. And what was interesting is they didn't tell anybody about this. They wrote a court order that they're discontinuing it. But if anybody used their site for e-filing, they would know about it. But if you didn't use the site for e-filing, you wouldn't know they were discontinuing the email, because the email was for pro se people who didn't go on their regular site. Like, why would you even be on their site? And there was nothing on their site that stated they were discontinuing the email. There was some court order. If you navigate the entire website, go looking through it, and opened up a court order, that's where it said that. Well, as it turned out, that they did give me, they did end up granting me permission to move forward with the appeal. It was very wrong what they did, not giving any kind of notice in any way. But they also have their other tactics to block people. As I said, summary action, they call it. They could say, well, we don't know if your appeal has any merit to file. The whole point of an appeal is to review, to see if you have good cause, if there was error of law, abuse of discretion. That's the entire point. So now they're trying to predetermine if you can even appeal by using this new tactic, or I don't know that it's new. I've never been through the federal courts, but a tactic called summary action. So we'll see, and I'll update you later down the road how that turns out.
Oh my goodness.
It never ends, Marianne.
Oh.
You just look, anybody, my recommendation, if you don't have to go through the court system, do not. If you have another option, if you can negotiate, if you're able to work things out with your opposing party, do it. I didn't ever get that option. I never had that option. I was dragged through these courts, and it's like they won't let you out. Yeah. There's no, it's a maze with no exit.
Oh, definitely. That's what happens when you're opposing is a personality disorder, because the people that can work it out, actually, we don't hear about, because they're mediating either between themselves or with their attorneys, and no one goes to court because they're smart and they're not a personality disorder. But
yes, I think I mentioned to you, a friend of mine, someone I know, this years ago, she had gone through a divorce, maybe about a year or 2 years after me. Her ex-husband, after about a year and a half, she said he wised up and he wasn't going to pay out all these legal fees and get dragged in and out of court, and he settled with her. She said he was mean, but he settled with her. But all the other folks I know of who, through all this divorce and family type of litigation, you're dealing with these narcissists, borderline personalities. My ex-husband doesn't even live in this country, and but he's got his teams of attorneys, And each time I try to make forward movement, and, just live an independent, quiet life, there's people who keep, interfering. So, I'm not making a choice. It's a survival tactic at this point. That's all, I can do. But anyway, so for all the folks out there listening, Marianne's new book, Raised by These Wolves, it's really an easy read. It's easy to understand. You can relate to it. You really are sympathetic to all these different cases, and it's not difficult and long to read. So go get that book if you can. My book is Court Gate, The Court's Divorce from the Law. I will say my book, I have to admit it now here, Mary, my book is not edited. It was never edited. It wasn't proofread. I didn't have financial ability to hire anyone to do it. So, and it's the first book I've ever written. When I come out with my second book, I can promise the listeners and readers that I will have my first book professionally edited, when it's copywritten, edited, proofread, and maybe, a little bit easier to read. And then I also mentioned to you Diane Diamond's book. Even though it's not divorce or family court, it involves the fundamental money surrounding your family. So the way I see it in different stages. Where did you end up in court? In divorce, family court, child custody stuff, or down the road in guardianship, or at the very end, you're already passed away and it's probate, and then it's your family or whoever's fighting over the probate. It's just a matter of which stage you're at, but it's not corporate business money, it's your family money. And it's really pathetic when you think about in divorce, in Pennsylvania especially, because you have to go to court to fight to get money that's already yours. When you're talking about divorce, marital assets, that money's already yours. And the court basically takes hold of it and they decide how they're going to split it up. If you live in a community property state, like I'm just giving California for an example, any monies or assets that are showing are automatically split 50-50, unless you have some kind of prenuptial agreement. It's 50-50, which is the way it should be. And I don't understand how our country cannot have marital assets be 50-50, with the exception of a prenuptial. That should be automatic. But the way Pennsylvania operates, you don't have a chance. You do not have a chance. So, okay, well, I was so happy that you invited me back. Folks, go get those books, educate yourself. And
I could put that link in the podcast notes for your book.
I'm sorry?
I could put in the podcast notes for for October 12th.
Sure. Thank you. I'd appreciate that. I'll put it up for the folks, a free, that's the ebook. You can read it on a computer or your phone. You don't have to have a Kindle device, but if you have one of those, you could do that. And I look forward to coming back again, Marianne. Keep up the good work.
You'll be back. And how can people reach you if they have any questions?
You know what? I think I have an email, courtgate@yahoo.com. So it's just courtgate@yahoo.com.
Okay, great. Now, don't jump off, okay?
Sure.
Slam the Gavels, a podcast, help the public understand what really goes on in these family courtrooms. I am your host, Marianne Petrie, author of Dismantling Family Court Corruption, Why Taking the Kids Was Not Enough, and Cry Out for Justice, Poems of Truth, and the recently released Raised by These Wolves, How Family and Federal Courts Are Failing Our Children. You can find me on Spotify, YouTube, Apple iTunes, Anchor FM, iHeartRadio, and feel free to donate to Buy Me a Coffee to help support this podcast. Thank you, Elaine.
Okay, thank you.